This module provided a complete understanding of how real estate financing operates within Arizona's legal framework, explaining not only the instruments used to secure loans, but also the roles of each party involved and the procedures that ensure lawful and enforceable transactions. It tied together the foundational concepts of trust deeds, mortgages, and promissory notes to illustrate how real property serves as collateral for borrowed funds. At the center of Arizona's lending system is the deed of trust, the most common security instrument used in the state. A deed of trust involves three distinct parties, each with clearly defined responsibilities under ARS. PANFOR 33-801 through 33-821. The truster is the borrower who pledges property as security for repayment. The beneficiary is the lender who holds the promissory note and benefits from the lien. And the trustee is a neutral third party, often a title company or attorney, who holds legal title to the property in trust until the debt is satisfied. The deed of trust structure allows for non-judicial foreclosure, meaning the trustee can sell the property through a trustee's sale if the borrower defaults, following strict statutory procedures for notice and publication. This streamlined process makes it faster and less expensive than a traditional court foreclosure, while still protecting borrower rights. The module then compared the deed of trust with the mortgage, a two-party instrument involving the mortgagor, borrower, and the mortgagee, lender. In a mortgage, the borrower retains legal title, while the lender holds a lien on the property as collateral. If the borrower defaults, foreclosure must proceed through the courts under ARS. Paragraph 33-721 et seq. A process known as judicial foreclosure. Although slower and more costly, this method provides judicial oversight and preserves the borrower's right of redemption, the right to reclaim the property by paying off the full debt within a statutory period after foreclosure. Both instruments serve the same purpose, securing the lender's interest in repayment, but differ in structure and procedure, with the deed of trust preferred in Arizona for efficiency. The third major component of real estate financing, the promissory note, establishes the borrower's personal obligation to repay the loan. It is the foundation of the lending relationship, outlining terms such as loan amount, interest rate, payment schedule, and default provisions. While the promissory note creates the debt, the deed of trust or mortgage secures it. Without the promissory note, there is no debt to enforce. Without the deed of trust or mortgage, there is no collateral for the lender to claim in case of default. Together, these instruments ensure both personal and property-based remedies for non-payment. The final section of this module addressed the legal documents and procedures required for securing a loan in Arizona, emphasizing the interplay of state and federal laws. The loan process begins with the execution of the promissory note and the accompanying security instrument, either a deed of trust or a mortgage. Federal disclosure laws such as the Truth in Lending Act, TILA, and Real Estate Settlement Procedures Act, RESPA, ensure borrowers receive key information about interest rates, fees, and repayment terms through documents like the Loan Estimate, LE, and Closing Disclosure, CD. Once all documents are executed, the deed of trust or mortgage must be recorded with the county recorder's office to provide constructive notice of the lender's lien and establish its priority over other encumbrances. Title companies play a critical role by preparing a preliminary title report to confirm ownership and ensure the property is free of undisclosed liens. At closing, escrow officers coordinate the distribution of loan funds, pay off prior debts, and record the new documents. After the loan is fully repaid, the lender must record a deed of release and reconveyance for deeds of trust, or a satisfaction of mortgage, removing the lien and restoring full ownership to the borrower. Failure to release the lien promptly can result in penalties under ARS. Paragraph 33-708. Through this module, several landmark Arizona court cases helped illustrate how lending instruments are interpreted and enforced. In Patton versus First Federal Savings and Loan Association of Phoenix, 1978, the Arizona Supreme Court recognized the deed of trust as distinct from a mortgage and validated the non-judicial foreclosure process. In Re Crone, 2002, clarified the borrower's dual rights, equitable title until foreclosure and redemption rights before sale. While Mid-Kansas Federal Savings and Loan Association vs. Dynamic Development Corp. Dollars, 1987, reaffirmed the judicial foreclosure process and the borrower's right to redemption under a mortgage. These cases demonstrate Arizona's balance between lender efficiency and borrower protection. By connecting these legal principles and procedures, the module made clear that lending in Arizona relies on both contractual and statutory precision. Every real estate loan must have a promissory note to establish debt, a security instrument to protect the lender's interest, compliance with disclosure laws to protect the borrower, and proper recordation to formalize the lien. In summary, the deed of trust involves three parties: truster, beneficiary, and trustee, and allows non-judicial foreclosure. The mortgage involves two parties, mortgagor and mortgagee, and requires judicial foreclosure with redemption rights. The promissory note establishes the borrower's personal promise to repay the loan. Loan security procedures include executing and recording documents, ensuring clear title, providing federal disclosures, and recording lien releases upon payoff. Landmark Arizona cases reinforce the validity of these procedures, ensuring fairness, transparency, and legal protection for both borrowers and lenders. Altogether, this module emphasized that understanding lending instruments is essential for real estate professionals, as these documents form the legal and financial foundation of property ownership, protect lender and borrower rights, and ensure confidence in Arizona's real estate market. Differentiate between various ways to hold ownership in Arizona. In previous sections, we explored how financing, title insurance, and escrow processes interact to facilitate real estate transactions in Arizona. Now, we move into the essential topic of ownership, which defines how title is held once property is acquired. Ownership forms determine not only who has legal control, but also how property transfers upon death, how it can be sold or encumbered, and how it is treated in marriage or partnership. Arizona's property ownership laws are deeply rooted in both statutory authority and long-standing legal traditions, blending community property principles with modern survivorship rights. Understanding these distinctions is critical for real estate professionals when assisting clients in selecting the most appropriate ownership form for their circumstances. Arizona recognizes several ways individuals or entities can hold title to real estate, including sole and separate property, community property with right of survivorship, joint tenancy with right of survivorship, and tenancy in common. Each carries unique legal and tax implications, especially concerning inheritance, liability, and the ability to transfer ownership. Sole and separate property refers to ownership by one individual without any co-owners. This form of ownership is common among single persons, divorced individuals, or married persons who have acquired property independently and wish to keep it separate from marital assets. Under ARS, Paragraph 25-213, property owned before marriage or acquired during marriage by gift, devise, or descent is considered the separate property of that spouse. For example, if Maria buys a home in Tucson before marrying, that property remains her sole and separate property unless she later transfers an interest to her spouse. To maintain this status, any conveyance involving her married name must include her spouse's disclaimer deed to confirm that the property is not part of the marital community. If Maria sells the property later, only her signature is required, ensuring full control. Sole and separate ownership offers autonomy but lacks survivorship rights. When the owner dies, the property passes through probate, unless held in a trust or another estate planning instrument. Community property. Arizona is one of 9 community property states in the U.S., where assets acquired during marriage are presumed to belong equally to both spouses, regardless of whose name appears on the title. Under ARS, paragraph 25-11, property acquired by either spouse during marriage, except by gift, devise, or descent, is community property. This means both spouses must consent to sell, encumber, or transfer the property. For example, if Mark and Olivia purchase a home in Gilbert during their marriage using shared income, that home is community property. Neither spouse can sell or mortgage it without the other's consent. Upon divorce, the property is typically divided equally, reflecting each spouse's 1/2 interest. However, community property does not automatically include survivorship rights. When one spouse dies, their half interest passes through probate, unless specifically designated otherwise in a will or through title selection. Community property with right of survivorship, CPWROS. To simplify the transfer of community property upon death, Arizona allows spouses to hold title as community property with right of survivorship, codified under ARS, paragraph 33, 431. This form combines the equal ownership benefits of community property with the probate avoiding feature of survivorship. When one spouse dies, their half automatically transfers to the surviving spouse, bypassing probate entirely. For instance, if Robert and Sandra own their Scottsdale home as community property with right of survivorship and Robert passes away, full ownership automatically vests in Sandra. This transfer happens by operation of law, ensuring continuity of ownership and simplifying estate administration. CPWROS provides tax advantages as well, including a double step-up in basis upon the first spouse's death. This adjustment minimizes capital gains taxes if the surviving spouse later sells the property, a benefit not available in most joint tenancy arrangements. Joint tenancy is a form of ownership where 2 or more people hold equal ownership shares with the right of survivorship. Each joint tenant has an undivided interest in the entire property, meaning all have equal rights to use, possess, and enjoy it. To create a valid joint tenancy in Arizona, all 4 unities must be present: time, title, interest, and possession. For example, 3 siblings, Emily, Paul, and Sophia, purchase a vacation home in Flagstaff as joint tenants. Each owns an equal 1/3 interest. If Paul passes away, his share automatically transfers to Emily and Sophia, not to his heirs, avoiding probate. However, joint tenancy is severed if one party sells or transfers their interest. If Emily sells her share to a third party, that new owner becomes a tenant in common with Sophia, and survivorship rights are lost. Joint tenancy can exist between unrelated parties. But in Arizona, married couples typically prefer community property with right of survivorship for tax and estate reasons. Joint tenancy with right of survivorship, JTWROS. This title form is similar to joint tenancy, but is often used explicitly to ensure that the right of survivorship is clearly stated in the recorded deed. Arizona law allows this title form under ARS paragraph 33, 431. The inclusion of survivorship language prevents confusion about whether the owners intended this benefit. For example, if 2 lifelong friends, Greg and Henry, purchase a Phoenix condominium as joint tenants with right of survivorship, and Greg dies unexpectedly, Henry automatically becomes the sole owner. No probate is required, and the property transfers immediately by operation of law. Tenancy in common is the most flexible and frequently used form of co-ownership in Arizona for unrelated parties or business partners. Unlike joint tenancy, tenants in common may hold unequal interests and may transfer or will their portion to anyone. There is no right of survivorship. Upon death, each owner's share passes according to their will or estate. For instance, if 2 investors, Lauren and Marcus, purchase a rental property in Mesa, Lauren contributing 70% of the funds and Marcus 30%. They can hold title as tenants in common with proportional ownership. If Marcus dies, his 30% share transfers to his heirs rather than to Lauren. Tenancy in common is particularly common in business and investment contexts, where ownership interests may change over time. However, because ownership shares pass through probate, this form lacks the automatic survivorship benefits that joint tenancy or CPW-ROS provide. Legal implications and practical considerations. Choosing a form of ownership affects everything from tax liability to transferability and inheritance. For married couples, community property or CPW-ROS provides tax benefits and simplicity. For business partners or unrelated individuals, tenancy in common provides flexibility. For single owners, sole and separate ownership ensures full control. The Arizona Supreme Court, in cases such as in Re Estate of Estelle, 1980, and Bender v. Bender, 1994, reinforced the importance of clear title language, emphasizing that ownership designation on the deed determines survivorship and inheritance rights. In Estate of Lamparella sur Lamparella, 2002, the court further clarified that even if property is acquired during marriage, title wording can determine whether it is community or separate property. Discussion: why might a married couple choose community property with right of survivorship instead of standard community property? Answer: because CPW-ROS allows the surviving spouse to inherit the deceased spouse's share automatically, avoiding probate and providing tax benefits. What happens to an owner's share in a tenancy in common upon their death? Answer: the owner's share passes to their heirs or according to their will, not automatically to the other co-owners. If two friends purchase property together but want their shares to go to their respective families upon death, what form of ownership should they choose? Answer: tenancy in common, because it allows each owner's share to transfer through their estate. Review summary. Ownership forms in Arizona determine how property rights are shared, transferred, and inherited. Sole and separate ownership provides full individual control. Community property ensures equal ownership between spouses. And community property with right of survivorship combines those benefits with automatic inheritance. Joint tenancy and joint tenancy with right of survivorship create equal ownership among multiple parties with survivorship rights, while tenancy in common offers flexibility for co-owners with different ownership shares and succession plans. Arizona's statutory framework, principally ARS, paragraph 25.211 through 25.213, and ARS, paragraph 33.431, along with key case law, establishes how these ownership forms operate and are interpreted. Understanding these distinctions allows real estate professionals to guide clients effectively, ensuring that ownership structure aligns with personal, financial, and estate planning goals.